The difference between defenses and counterclaims in debt litigation. Brought to you by T. Rex Hogan at FightDebtNow.com, a resource for people being sued by debt collectors. Sometimes my clients ask me very good questions. Recently, one of them asked me what would happen if he didn't file an answer, but just wrote a counterclaim instead, pointing out some of the things that he thought the debt collector had done to him. So that brings up a question. Is a counterclaim a defense to a lawsuit brought by a debt collector, or is it something else? Generally, a counterclaim is not a defense. A claim is one person's legal right or basis for suing another person. A counterclaim, on the other hand, is the other person's right to sue someone who is already suing him. The difference in names just reflects who started the suing. Sometimes two claims are so closely related that the counterclaim is said to be a mandatory counterclaim, and that means it'll be lost if it's not brought as a counterclaim in the original lawsuit. A good example of that might be an automobile accident in which both drivers were hurt. Either person could bring a lawsuit against the other one. Obviously, somebody has to bring the lawsuit first, and whoever does bring the claim first will be known as the plaintiff, but the other person has to sue back at the same time and in the same court. Otherwise, the courts would be conducting lawsuits on the same facts over and over again, and that would raise the possibility of inconsistent results, as well as wasting a lot of time and resources by the courts. In debt law, claims brought under the Fair Debt Collection Practices Act, also known as the FDCPA, are specifically not mandatory. Some people bring them after the case against them is over, or even in a different court, at the same time or at some other time. And with a few possible minor exceptions, a claim under the FDCPA is not a defense to the debt if you're being sued. In real life, though, if you bring a good FDCPA counterclaim against a debt collector, they may very well want to settle the whole thing, so it can be a good tactic. It takes a lot of the fun out of things for the debt collector if you sue them back. So that's it for counterclaims. A defense is proof that you don't owe the debt collector any money, or that they can't prove that you do. You could plead and prove, for example, that you never borrowed the money at all, or that you paid it all back. Or you could show that the creditor or debt collector settled the debt with you and agreed to accept less, or that the debt was discharged in bankruptcy, or that the debt is too old for collection. That's known as the statute of limitations defense, among other things. And some of those other things might include an attack on the specific amount of money that the debt collector claims is owed. These things all go to whether or not you owed the debt collector any money, and that's what makes them defenses. If you prove a defense, you won't owe the debt collector any money, or you'll owe the debt collector less money than they claim in the first place. If you prove a counterclaim and not a defense, then both parties might owe each other money. The rights are independent, although the ultimate amount of money might be offset, so that you just end up with a net figure one way or the other. So the moral of the story is that it is wise to plead and prove both a defense and a counterclaim. To get more help on fighting debt collectors and their lawsuits, go to FightDebtNow.com. Get my litigation manual and forms, and arm yourself to win.